First question for you tonight, Joseph, is from our viewer, Ryan McLaughlin, on the process of the inquiry. Have a listen.
Well, you know what? The last impeachment process, I guess, that I lived through was Bill Clinton's, when that whole thing came up. So I don't really know how that works, how the whole thing goes. You know, who's the one that basically brings this to whole fruition?
All right, that is a big question, Joseph, and I'm sure a lot of people are looking for an answer. So let's break it down a little bit. First of all, what does it mean to be impeached?
Sure, Carol. So sadly, I am old enough to remember the Bill Clinton impeachment very well, actually. Think of impeachment as charges that are being brought. So on the criminal side, we call it an indictment. It is not a trial. It is not a finding of guilt. And in the case of impeachment, it's not removal. And a lot of people think it's one and the same. It's simply the process that in our lower chamber of Congress, which is the House of Representatives, a simple majority can vote on one or more articles of impeachment to say, we believe there is probable cause that the president committed treason, bribery, or other high crimes and misdemeanors. That's the standard in our Constitution. So think of it as, on the criminal side, if a person is arrested and charged, that's the same stage of the process as we would be if the president is impeached on one or more impeachment articles.
Okay. Are these impeachment articles necessarily crimes?
So I just read the standard from the Constitution, which says treason, bribery, and high crimes and misdemeanors. So you would think they should be criminally related, but the reality is it's effectively anything the House members say it is. So you would think there should be an underlying crime there, but I can certainly see a scenario where you may not have a criminal violation, but a majority of the House might say, this is behavior that we don't think is acceptable. And so even if perhaps there is not a strict violation of some federal law, we don't think a member, a president should remain in office if he or she has done this or that or something else. So that could be the scenario where we're in here. It does not strictly have to be a crime to be impeachable.
Okay, one more follow-up question, Joseph. So if you are impeached as a president, and using your analogy, it means you're charged but not convicted. Where does the trial happen?
So then it goes to the upper chamber of Congress, which is the Senate. So what happens is there are selected, what they call managers from the House of Representatives who act as prosecutors. There is a trial, and the jury consists of all 100 members of the Senate, each of whom get a vote. The presiding judge is the Chief Justice of our Supreme Court, who sits there and makes rulings about evidence and testimony and things like that. It takes a 2/3 supermajority in the Senate to convict. So you need 67 out of 100 senators to vote to convict the president. And then there's only one sentence. That's removal. There's no fines. There's no prison. It's not a criminal, proceeding. It's simply, if you're not guilty, you stay in office, and if you're guilty, you are removed. And I would add that even though we've had 2 presidents impeached in our country's history, we've never had someone actually removed by the Senate.
All right. Well, the question comes from Yelena, and she tweeted, is the president of Ukraine in any trouble, or is he a witness to this mess? Joseph, what do you think?
Well, Yelena, it's a good question. He's not in any trouble. As far as being a witness, I suppose he is, but we've basically heard his evidence, right? We've seen his words on the transcript, and we heard in a press conference that he had with President Trump in New York today, his reaction to the questions and his recollection of the phone call. So that's probably all we're going to hear from the president of Ukraine. I can't possibly imagine he would appear before the House or the Senate in a trial against President Trump. So I think that what we've heard from him is probably all we're going to get there.
All right, speaking of appearances, Nancy has a question about the whistleblower, and she tweeted this. Will the whistleblower get to testify in public, or will Barr, meaning the U.S. Attorney General, be ordered by Trump to allow the use of executive privilege? Joe?
Nancy, I like that question. So we've heard from the whistleblower's lawyer that he or she, we don't know who it is is willing to testify. And we know that Adam Schiff, who is the chairman of the House Judiciary Committee, is eager to make that happen. So it sounds like from the whistleblower's perspective, that person does want to testify. Now, could the president or the Justice Department or the intelligence community prevent that person from testifying? I suppose they could try. They could argue executive privilege or classification or some argument like that. It's unlikely they would succeed now that we know the person exists and Congress wants to hear that testimony. So more likely than not, we will hear directly from that person what he or she has to say.
And what is executive privilege?
Well, executive privilege is this concept. It's not a law. It's basically case law that says that the president has the right to get advice from his or her advisors and to keep that advice confidential, right, so that it doesn't get disclosed. But it's not meant to cover every single communication within the executive branch. And it has been stretched over the years to something that we really kind of don't recognize anymore. President Nixon, back in 1972, was slapped down by the Supreme Court, and ultimately his claims of privilege were rejected, and he had to turn over the Watergate tapes. So here, if President Trump tries to stretch it too far, I think he'd have a hard time in the courts.
Okay. Joseph, what do you think? Do you think, I'll ask you to address a couple of things, that issue in general, but also how much the credibility of the whistleblower will come into play?
So I guess we have to hear what that person has to say. I mean, I'm assuming that it's going to build on this Ukrainian telephone transcript, and so, but then we've also heard reporting that the person did not have firsthand knowledge of the conversation. So the person could simply have just repeated what he or she heard about this conversation, and now we've seen the transcript. So it might really not add anything. We obviously should hear it, and we should analyze it, but it might not add much to the story. And as far as what Julia said, I absolutely agree here. I mean, when you are a prosecutor, you have to know your jury, and you may think you have the best case in the world. But if you don't think it's going to play before a jury, if you don't think they're going to believe what you're saying, or they're going to think that your case is serious, you have to really consider whether to take it. And even though, while I said earlier, technically the jury is the 100 members of the Senate, they will actually vote on any trial that may or may not happen, but really it's the American people. And if members of Congress feel like, you know what, we may think this is a great case and President Trump's conduct was horrible, but if the American people aren't behind it, is it really a road we want to go down if we know ultimately it's not going to get us anything more than a symbolic victory?
All right, we'll leave it on that note tonight. I want to thank you both very much. Joseph Moreno, former federal prosecutor, and Julia Manchester, a political reporter at The Hill. Thank you for joining me from Washington tonight. Very helpful.
Thanks, Carol.
Thanks, Carol. Always a pleasure.
Coming up.